ठीक है, केस का नाम लिखेंगे, यू पीपल राइट डाउन. इट इज अ लैंडमार्क जजमेंट ऑन ऑर्डर टू रूल टू गुरबख्श सिंह वर्सेस भूरालाल. यस, सो आई विल बी रीडिंग द हेल्ड पार्ट ऑफ दिस, इसके बाद इसको डिक्टेट में करवाऊंगा आपको. ठीक है, जस्ट सी what is written. It is saying that a plea under order to rule 2 of code is based upon the existence of former pleadings cannot be entertained when the pleadings on which it rests has not been produced. ध्यान से देखो, a plea under order to rule 2 of the court is based upon the existence of the formal pleadings, that the existence of former pleadings cannot be entertained when the pleadings on which it rests has not been produced. So it means what? Like if you are saying that this subsequent suit is barred by order to rule 2 and there was already the matter earlier decided by the court and the party was entitled to claim certain reliefs, the court is going to hear your this objection only when you are going to produce the pleadings of the former suit in the court, correct? Pleadings. Further it is saying, it is for this reason that the plea of the bar of order to rule 2 of the court can be established only if the defendant files in evidence the pleadings in the previous suit, right? तो defendant को अगर objection उठाना है, if the defendant is raising objection of order to rule 2, what evidence defendant has to give in the court? Yes everyone, pleadings of the previous suit, and thereby proves to the court that identity of the cause of action in the two suits. He has to prove, like whatever the cause of action was there earlier in the former suit, the same cause of action is there in the subsequent suit also. In other words, the plea of order to rule 2 of the court cannot be made out except on the proof of plaint in the previous suit and the filing of which is said to create a bar. Without placing before the court the plaint in which those facts were alleged, the defendant cannot invite the court to speculate or infer by the process of deduction what those facts might be with reference to the relief which were then claimed. So without producing the plaint of the former suit, the court cannot come to any conclusion. That is the point which is being stated over here. Furthermore, the second point is, in order that the plea of bar of order to rule 2 subrule 3 of the court should succeed, the defendant who raises the plea must make out what? That the second suit was in respect of the same cause of action as that on which the previous suit was based. So in the previous suit as well as in the subsequent suit, the cause of action is altogether same. That in respect of the cause of action, the plaintiff was entitled to more than one relief. At the earlier suit, when he was contesting, plaintiff was entitled to more than one relief. Number 3, that being thus entitled to more than one relief, plaintiff without leave obtained from the court omitted to sue for the relief for which the subsequent suit had been filed. So these are the 3 points which we have to see as far as the application of order to rule 2 is concerned. Yeah, you write down the name. It is Cuddalore Powergen Corporation Limited. Cuddalore Powergen Corporation Limited versus Messrs Chemplast Cuddalore Vinyls Limited. So if you people see the index of this, ठीक है, the judgment which I had given, तो उसमें you people will be getting the index also. We don't have to see the submissions of the appellant or respondent in this case because it is a factual thing. What we have to see, it is here. Journal principles underlying order to rule 2 of CPC, that is given in page number 27. Stage of the first suit is immaterial for the applicability of order to rule 2 CPC, that is there in section page number 41. Furthermore, it is related with the concept of rejection of plaint also, but rejection of plaint concept we people have not done yet, है ना? That is in order 7 rule 11, but yes, it is having the connectivity over there also. Yeah, so in this judgment, as you people can see, it is written in para number 36, page number 27, journal principles underlying order to rule 2, right? दिख रहा है ना सभी को? everyone? हाँ. What is written? The object of both Rule 1 and Rule 2 of Order 2. Rule 1, Rule 2. Rule 1 says, yes everyone, the suit should be so framed that there should not be any possibility of any further litigation. Correct? यही है ना Rule 1 में. And Rule 2 is dealing with several scenarios like when you can relinquish a part of the claim or when you can relinquish the relief. तो उसी की बात है. The object of both the rules of Order 2 is to prevent the multiplicity of the suits. Order 2 Rule 2 is founded on the principle that a person should not be vexed twice for one and the same cause. It is the rule which is directed against two evils. One is splitting of the claims and other one is splitting up the remedies. Splitting up the claims, where it is there in Order 2? Yes everyone. कौन से सब रूल में है? Order 2 Rule 2 Sub Rule 2. And splitting of remedies कहाँ मिलेगा? Order 2 Rule 2 Sub Rule 3. Remedies means the relief and claims, as I told you. What Order 2 Rule 2 requires is the inclusion of the whole claim arising in respect of one and the same cause of action in one suit. So if you are having a particular claim against someone, you have to raise that whole of the claim in one suit itself. There should not be any possibility of filing a subsequent suit thereafter. However, this must not be misunderstood to mean every suit shall include every claim or every cause of action which the plaintiff may have against the defendant. Therefore, where the causes of action is different in two suits, Order 2 Rule 2 would have, yes everyone, no application. Okay. Right? Further above, let me tell you people, if you people read the further paragraph, that is para number 38, so whatever we have discussed in the last session as well as in the today's session, वो सब कुछ यहाँ पे आपको मिल जाएगा. Like what is the difference between Order 2 Rule 2 Sub Rule 2 as well as Order 2 Rule 2 Sub Rule 3, and जैसे यहाँ पे आप लोग देख भी सकते हैं ये. In Order 2 Rule 2 Sub Rule 3, in situations where the plaintiff is entitled to more than one relief on the particular cause of action omits to sue, in such a situation, plaintiff is precluded from bringing a subsequent suit to claim the relief earlier omitted except in the situation where the leave of the court was obtained. It is therefore clear from the co-joint reading of Order 2 Rule 2 Sub Rule 2 and Sub Rule 3 CPC that the two sub rules are contemplated with two different situations. दोनों में अलग-अलग बातें हैं, same बात नहीं है. Done in para number 44. Just see, बहुत important बात है. It is saying the phrase cause of action. लिखा है ना Order 2 Rule 2 में that from the same cause of action. लिखा हुआ है Order 2 Rule 2 Sub Rule 2 में from the same cause of action. So they have interpreted the term cause of action. They are saying the phrase cause of action for the purpose of Order 2 Rule 2 would mean the cause of action which gives an occasion for and forms the foundation of the suit. If that cause enables a person to ask a larger and wider relief, then that too which he limits his claim, he cannot be permitted to recover the balance relief through independent proceedings afterwards. So this is the interpretation is given with respect to the word cause of action. So cause of action is basically something which is forming the foundation of the suit. Right? ये लिखा हुआ है. Cause of action is something which forms the foundation of suit, and if something which is forming the foundation of suit, you're entitled to certain claim, you are limiting your claim, you are not claiming everything, but you want to claim something in the subsequent independent case, you will be barred to proceed for that. Then the constitutional bench judgment that I had given you people, the head note of that case we have discussed already, Gurbakh Singh versus Bhuralal, correct? कर लिया कि नहीं किया बताओ? Right, and all the pointers in respect of the cause of action, the plaintiff was entitled to more than one relief, etc., etc. Whatever we have discussed right now, वो सब यहाँ पे है. Then the next point is, in this particular case, the stage of first suit is immaterial for the applicability of Order 2 Rule 2 CPC. Like what was the stage of the first suit, or what is the status of that first suit? It is immaterial. What is written? It is saying, the careful perusal of Order 2 Rule 2 would indicate that it does not impose any restriction on the applicability of the principles therein based on the stage or status of the first suit. In other words, there is no clear requirement that the first suit either be pending or disposed. Very important. रेस सबजुडिस और रेस जुडिकाटा का कॉम्बिनेशन है ऑर्डर टू रूल 2. ओके, रेस जुडिकाटा एंड रेस सबजुडिस दोनों का कॉम्बिनेशन दिखता है आपको यहां पे. व्हाट इट इज सेइंग, इन अदर वर्ड्स, there is no clear requirement that the first suit is pending or disposed of in order to make a plea of bar of order to rule 2 as regards the second or subsequent suit. It is conspicuous by the absence of such stipulation that the lawmakers, though fit that the bar under this provision would apply even if there is an identity in the cause of action in both the suits, irrespective of whether the first stage is disposed of or not. Very, very important point. As it is written, है ना, like it is quite possible है ना, that plaintiff may be entitled to a relief, but the relief was not available at a certain point of time. So what is meant by this? Like the concept which I had told you, like further reliefs. So you are entitled, but that relief is right now not available for you. So it is on that scenario, order to rule 2 will not be applicable. So that is the interpretation Honorable Supreme Court has given on this point. Furthermore, I think all the things are done. And had you people written the month of the judgment? Yes or no? This judgment is of 15th of January 2025. 15th of January 2025. So almost whatever the things which are related with order to rule 2, that I had told. Few other aspects which are related with order 7 rule 11 of CPC, that is related with the concept of rejection of plaint. So at the time when I will be discussing with you people the concept of rejection, again I will take up this judgment and we will read that particular portion at that point of time, right? But as far as the concerned provision that we were discussing right now, everything is done. I hope it is clear, everyone, please. Problem is there, right? So chalo, that's all for today. Baki you people revise your things. ठीक है? Take care. Good night. Bye bye. Okay. Okay. Take care.
Thank you, sir.
Okay, beta.